So, you hear a law called the Fair Election Act, and you think, great, sounds fair. But what if I told you that its critics claimed it was a total bait and switch, a kind of legislative trick? Well, that's exactly the story here. A huge legal battle that didn't just stop anywhere, it went all the way to the Supreme Court.
And really, this whole thing hangs on one simple question, one we all kind of have to ask. Can you trust a law's title to tell you what it's really doing? Can you trust the label on the tin, so to speak? Let's dive in and see what happens when that very idea gets put on trial.
Okay, so what was the big deal? What was all the fuss about? Well, before 2001, we had this pretty straightforward rule. It was basically, you run, you resign. So imagine you're a mayor, and you decide you want to run for governor. The second you file that paperwork, boom, you're no longer the mayor. Your old job is gone. But then, the Fair Election Act comes along and completely flips the script. Now, you can run for that new office and hold on to your current seat. A massive change.
But of course, it wasn't that simple. You can't just change a rule like that without some pushback. And this change, it kicked off a huge constitutional showdown. It all came down to this really important, kind of foundational idea in our law, the one subject, one title rule.
So what in the world is that? Well, think of it like a truth in advertising requirement, but for laws. It's super simple. A bill has to be about one main thing, and that one thing has to be clear from the title. You know, you can't have a bill called, say, the Puppy Protection Act that has a little tiny hidden section in it that also bans ice cream on Tuesdays. The title has to match what's inside. It's our constitutional safeguard against sneaky legislative moves.
And just to be clear, this isn't some friendly suggestion or a best practice. Nope. It is written right there, black and white, in the Constitution. This single sentence. This is the legal bedrock for the entire fight we're talking about today.
Now, why do we even have this rule? It's to stop a shady political tactic called log rolling. Here's how it works. You take something nobody wants, like, say, a really unpopular tax hike, and you secretly attach it to a bill that everybody loves, like funding for hospitals. The hope is that the good bill will carry the bad one along with it. The one subject, one title rule is there specifically to shut that kind of thing down.
And that brings us to our main challenger, Henry Giron. He looked at the Fair Election Act and said, wait a minute, this is exactly what the Constitution forbids. He believed this law was a classic case of bundling a bunch of unrelated stuff under one big misleading name, and he was so convinced he took that fight all the way to the top, to the Supreme Court.
So let's get into the weeds of his argument. He said, look, the title talks about fair election practices, which everyone thought meant things like rules for political ads. But, he argued, tucked inside were two completely different subjects. First, getting rid of that you run, you resign rule, and second, some new rules about substituting candidates. The big question for the court was, were these things really unrelated and hidden, or did they actually fit under the umbrella of fair elections?
All right, so the case lands on the Supreme Court's desk, and now they basically have to become detectives. They can't just accept the petitioner's argument at face value. No, they have to conduct a full-blown investigation, putting the Fair Election Act itself under a microscope and running it through a serious constitutional stress test.
So, where do they start? Well, the court always begins with a default setting, you could say. They presume that any law passed by Congress is constitutional. It's a sign of respect for the other branches of government. This means if you want to challenge a law, the burden of proof is on you, and it's a huge burden. You have to show a clear and unmistakable breach of the Constitution. That is a very, very high bar to clear.
And they didn't just wing it. The justices had a very methodical four-step game plan. Step 1, start with that presumption of constitutionality we just talked about. Step 2, look back at previous cases, the precedent, to see how similar issues were handled. Step 3, analyze the actual words in the title. How broad is it? How narrow? And Step 4, and this is the really interesting part, they went digging through the historical records to figure out what the heck the lawmakers were actually thinking when they wrote the bill.
When they got to Step 3, analyzing the title, the court had a different take than the petitioner. They didn't see it as a narrow title about just one thing. They read an act to enhance elections through fair election practices and thought, wow, that's a pretty big umbrella. They concluded it was written that way on purpose, to be comprehensive and cover a whole range of things related to making elections more fair.
And then they found the smoking gun. When they were digging through those legislative records, Step 4, they found this quote, a direct quote from one of the senators in the committee deliberations. And it's a bombshell. It basically says, yeah, we're looking for a more generic title so we don't run into constitutional problems. This wasn't an accident. They knew exactly what they were doing. They were fully aware of the rule and chose a broad title on purpose to make sure all their changes would fit.
So, you put it all together, and the picture becomes crystal clear. The records show that the lawmakers, 1, knew about the constitutional issue. 2, they deliberately picked a broad title to cover everything. 3, they actually considered the you run, you resign rule to be an unfair election practice. And 4, their whole mission was to, in their words, level the playing field. It was all part of a single, coherent plan.
Okay, so the investigation is over, the evidence is in, the arguments have been made, now it's Judgment Day. Time for the Supreme Court to hand down its decision.
And here it is, the heart of the ruling. The court was convinced. They said the title and the goals of the Fair Election Act were, and I'm quoting here, comprehensive enough to include getting rid of that automatic resignation rule. The legal term they used is germane, which is just a fancy way of saying it was relevant, it was connected to the main topic.
And with that, the case was over. The petition was dismissed, the challenge failed, the law stands.
But the court didn't stop there. They made one final, really important point about their own role in our government. They basically said, listen, our job is not to decide if this law is smart or a good idea. Our only job is to decide if it's constitutional. Deciding if a law is wise or not, that's the job of Congress. That's for the lawmakers to debate, not the courts. So, at the end of the day, this case leaves us with a really fascinating question to chew on. We've established that a law's title can be pretty darn broad. But is there a line? Is there a point where a title becomes too broad, too vague to mean anything? And maybe more importantly, who gets to draw that line? Who decides when a title has been stretched so far that it finally snaps? That's something to think about.